Hello, everyone. Welcome to our talk today. I am Mark Gilfix. I'm here with Michael Gilfix, my esteemed boss slash father. And we have a really interesting talk today. We're entitling it Tie Me to the Mast. And it's really issues around capacity and what can you do to plan for that time where maybe you have memory issues or dementia issues and the challenges associated with that. And this is going to be more of a Q&A type discussion. We're not going to give a bunch of detailed slides here because this is an issue that we think deserves more nuanced discussion. We will talk about action items. We will talk about steps you can take right now. But I think this is a really challenging issue as more and more Americans, we are staying physically healthy longer, but mental health, dementia, Alzheimer's, and issues around that can be really, really challenging. And so when do you take action? What can you do to plan ahead? And what do you do when you're in those gray areas or when you're even past those? So Mike, any thoughts before we officially dive in? I see a lot of people joining us, so welcome everybody.
The reason we thought we would do this is I just had my 50th law school reunion at Stanford Law School. And because of the work that I'm known for, a number of members of my class asked me to give a talk on this topic. I actually had a letter to the editor in the Wall Street Journal published, and it made reference to Tie Me to the Mast, which we'll talk about a little bit later. And the responses that I got were, frankly, amazingly, unanimously positive that everybody got great value. They're issues they know they need to be thinking about. So
these were Stanford lawyers. That doesn't really represent the general population. So,
but they're aging lawyers.
Yeah, right.
They're aging lawyers.
Right. So and this is an issue not just for us, it's also for the next generation. That's why it's good that I'm here, because some of this is going to be a learning process for me, how my father is thinking about this and what I should be doing as the adult child ahead of time as far as discussions and thinking about this. And we're here to talk about the issues around capacity and aging and ensuring that you retain the control that you need, but that you work with your family and loved ones to make sure that you're protected if and when the time comes when maybe you can't manage your affairs so well as a result of dementia or Alzheimer's or serious memory or mental issues. So Mike, what do we mean by tie me to the mast? We're actually going to stop sharing the slides because it's going to be a discussion, right? So we're going to go through Q&A. What do you mean by tie me to the mast, and what are we talking about here?
Sure. So, as I do this, Mark mentioned, we really encourage you to ask questions. We want to make this interactive, make sure we address any issues or questions that you have. My guess is many questions are going to occur to you. All right, tie me to the mast. Those of us who actually were educated about Western civilization and read the classics, you already know what I'm talking about. This is the story of Odysseus, or Ulysses. I think it's the Romanized name for Odysseus, who was captaining a ship and was very aware of the fact that those who traversed that particular area of the ocean would be waylaid, would be called by the sirens, who had these wailing voices that attracted you to come toward the island, and then you would go up on these rocks and you would crash and everybody would drown. The strength of Odysseus, and here's the point, was that he knew he was weak. He didn't think he could withstand the sirens. He saw susceptibility and he did something about it. So what he did was he had his crew put stuffing in their ear so they wouldn't hear it, but he was the boss man and he was worried about what he would do. So he literally had his crew tie him to the mast so he couldn't intercede and try to steer the ship in the wrong direction. He knew that he was weak and susceptible. And isn't that the case? I mean, any one of us can develop some memory issues, some capacity issues, and some judgment issues. So again, to be proactive about this, by the way, the side note is there was an article in the Wall Street Journal about memory and aging and all of that. And I sent in a letter to the editor, somewhat tongue-in-cheek, somewhat real, where I basically said, hey, I told my kids, if I develop these really serious memory and capacity issues, tie me to the mast. Make sure that I don't go out there and make trouble and do something stupid. That's the source. That's from which it emanates. And, again, it's everybody's topic. Mark has some data on the number of individuals who suffer from advanced dementia. But, as we get older, we worry about memory. There's a lot of words. There's memory, there's capacity, and there's competency. They're different. They all have their nuances, and definitely they have significance when we're taking care of our lives, and certainly in the context of our legal planning documents.
Let's circle back. So capacity, you talked about statistics, and I was just looking at some recent statistics. Over 5.8 million Americans suffer from Alzheimer's or some form of dementia. And that's what we're talking about here when you have mental capacity issues. And I want to make one thing really clear. We are big believers that you should have the right to control your estate plan, to control your life until it's dangerous, until you really have capacity issues. Just because you have a diagnosis of certainly physical issues, if it's cancer or something like that, that doesn't mean you don't have capacity. You might be physically weakened. You can still absolutely likely manage your affairs. This is really mainly about dementia diagnosis. And when you're showing issues around memory and managing your affairs, that's really what we're talking about here. So we want to get clear, just because you get physically sick, you shouldn't lose the ability to make decisions.
Yeah. And you're actually making a point about ageism, that, is there an automatic assumption that because you're over 70, over 80, over 90, whatever, that suddenly you're not capable just because of your age before anybody even talks to you, or they'll hear some words from you that if you said them when you were 50, nothing. But now that you're 80, oh boy, that shows it.
Exactly. Or you're diagnosed with a different type of illness. Many of you may have seen my story. I went through my own cancer journey 4.5 years ago. The idea that you should lose the ability to make decisions just because you're diagnosed with some issue is absurd. But there are positions where it does matter. When you're showing signs, really, we're talking about more mental issues. When we talk about capacity, the ability to make decisions, can you go through how the law sort of defines that and why it's kind of a circular definition and a bit challenging?
I want to share first, because this is actually responsive to your question in very practical terms. I author a form book for other attorneys. A couple thousand attorneys around the country buy the form book. I co-author it with a couple of law professors, one in Florida, one in Kansas. And in the chapter on capacity, which I author, I wrote about the Ulysses Clause, which I created. So I signed a Ulysses Clause. So it says this, and again, this gets to Mark's question. It says, and I address it to my family, and I address it to my successor trustee in my trust. I address it to the person named in my durable power of attorney. I basically say, if I exhibit any of the following behaviors, I want you to intervene. I want you to speak up and ask me about it and pursue it. So often there is resistance and worry that you'll be overbearing, that you're intruding where you shouldn't be, that you're being ageist, that it's uncomfortable for you to challenge your parent or another loved one who is older or not older, but who is having these issues. So I'm trying to take responsibility for the issue. So mine says this. In part, it says, if I exhibit these behaviors, intervene. Number one, am I not paying bills, even though I always did pay my bills before? Am I paying the same bill 2 times, 3 times? Am I suddenly making gifts to charities that I never gave to before? Am I suddenly entering contests where I can win $2 million if I just send off $3,000? Am I doing something really stupid in that context? Am I suddenly making gifts to people I never made gifts to before? Am I signing documents and committing myself in ways that I never, ever, ever did before? And it's not on my list, but I certainly have told everybody that if I start to do crazy things driving my car, intervene. My point there is it doesn't say if I become incapacitated. It doesn't say if I have memory issues. It says if I exhibit these behaviors, hey, check it out. I mean, that's reality, and that's the approach that I think makes the most sense.
So it's looking for specific behaviors or issues, and from there, then maybe it's time to check it out. Because the issue of defining incapacity, it's challenging, and we know that we have some clients who have had a diagnosis of you have some dementia, but that doesn't mean they can't make decisions, right? They might have times of day where they can. Of course, we have to be extra careful, but just because you have a diagnosis doesn't mean you can't. So you're saying that a good approach is to say, hey, family, if you see these behaviors, then it's time maybe to check it out. And what would you say if a family does? Like, let's say, Dad, I see that you are driving erratically, or I see that you're paying bills 2 or 3 times. What should I do?
I would want you to talk with me and point this out. And if I'm in denial about it, that's a red flag to you. If I say, gee, you're right, I see that. I would hope that would be my response. And we would talk about it. And maybe I would I don't know what I would do. Maybe I would say I should no longer be trustee of my trust, or I want to limit the damage. I'll have a bank account in my name that only has $5,000 in it. Everything else is under somebody else's control. For many folks, by the way, when this issue comes up, many individuals will name maybe your kid, your successor trustee, as a co-trustee with you. And then in the trust, we can say 2 signatures are needed for any transaction involving $5,000 or more. 3,000, 8,000, 10,000. So that means that each person individually, each co-trustee, parent and child, can write a check to pay a bill, no big deal, but you're building in a level of control. What I like about that is you're not saying a person lacks capacity. You're saying, hey, good to have a little help and a little assistance here. Let's not have somebody conclude that you lack capacity, which most trusts say. They say if the creator of the trust is the trustee, and they no longer have capacity in the context of managing the trust, they're to be removed and the next person takes over. You have to get doctor letters, whatever the trust may say. But again, a much more respectful way of dealing with this is to see about a resignation or, again, amending the trust so that somebody becomes a co-trustee with you. It's practical and it's gentle and it's respectful.
Absolutely. And I think it's really critical, of course, that you have your estate plan in place, of course, ahead of time. You have an up-to-date living trust, up-to-date powers of attorney. And I like that idea that just because you have a document in place doesn't mean that it's going to be all encompassing or perfect, that the idea of separating out finances and having smaller accounts you have control over, well, you can retain some control but limit damage. I like that idea. And the idea of co-trustees, where you say, look, I don't want to give up control, but I'm going to name my child or my spouse or someone to step in right away to oversee things with me. So why don't you go over an action item list? Like, are there some specific steps that you can take right now? Let's say, and we're going to go through, we have some great questions here. So many good questions. We're going to get to some of those. What are some of the steps? Let's say early stage. So you said we should talk if we see these issues. What if someone's resistant? This is, let's say I talk to you, Dad, and at this point you're like, no, I'm fine. I don't have an issue with this. As an adult child, still a child in many ways, what should I, what do you do? How do you push back if the elder parent or elder individual loved one is sort of pushing back and saying, no, I'm fine? What would you suggest at that point?
Well, the first thing to say is, everybody's different. And all family dynamics are different. So there's clearly no, one size fits all. But, I really think it's, we always say we deal in reality. And for me, I really believe that's ingrained. I've been saying it for about 55 years as I've been doing this kind of planning, this kind of work. So, I understand that aging has issues, obviously. Memory can be compromised, obviously. So I think that I would be a little more open to it. I also did the Ulysses Clause. So you can see that I've taken proactive steps to acknowledge the possibility. Okay, but let's go with what you said. And let's say I'm resistant. If you see that if somebody out there sees their parent doing financially dangerous things, you have to intervene. And by the way, the beauty of doing appropriate estate planning documents is that you can utilize those documents and you don't have to go to court. God forbid, you have to go to court to set up a conservatorship. Legal fees, the intrusiveness of the courts.
Let me jump in there. And that's what happens if you don't have documents and if you don't get any cooperation, by the way. So if nobody can talk, if nobody's communicating, if a parent's really resisting and refuses to cooperate and is taking lots of bad steps, sometimes we're really stuck. You have to go to court. You have to prove in public that your parent or your loved one has no capacity, doesn't have the ability to manage things. And that sucks. We don't want that to happen. That costs thousands of dollars. They have the right to challenge it. You might not even get it. The court oversees everything. So really what we're talking about here is what can you do to stay out of the courts ahead of time. So sorry, just wanted to flag that we don't want conservatorships. This is all about avoiding the Britney Spears style conservatorship.
One of our guiding principles in this law firm is to keep people out of the court system. And certainly the conservatorship comes up when there's a question of capacity. With younger folks, if it's special needs, sometimes a conservatorship is unavoidable. Sometimes with us older folks, a conservatorship is unavoidable. But again, with good planning, 95% of the time you can avoid that. If you're watching this, you're probably one of our clients. You may not be, or you may not be yet, but the documents we prepare are designed to take into account this possibility. So let's say again, let's go back to the question. I'm not buying it. I'm resisting. I'm just saying, hey, get out of here. I know what I'm doing. Well, The trust where the assets are held, it says that if two doctors, we take different approaches in different trusts. If two doctors, including my attending physician, indicate that I have lost the ability to manage money and make appropriate financial decisions, that I should be removed and no longer serve as trustee. And by the way, you'll notice that that language that I just used didn't have some global conclusion about has dementia or lacks capacity. It's functional. It's can't manage the trust. That's what it's all about. If there's resistance, and if my doctor and a second doctor conclude that I really lack the ability to do it, you have the hammer. And I could theoretically get a lawyer and go to court to fight it, or go to another doctor and get a different opinion. Of course, all of those things can happen. But in real life, when this issue comes up and the kids or the next trustee intervenes because there's issues, I'll tell you, the issue tends to be resolved. Theoretically, many things could be done to make it complicated, but as a practical matter, it usually doesn't. Once those affirmative steps are taken to grapple with it, it becomes an issue that everybody has to acknowledge and resolve one way or another.
Cooperation ahead of time and communicating ahead of time and thinking about this ahead of time is just so crucial. Let's talk about the care side. Let's say that, so I think we talked about you need to have an estate plan in place. You have to have an up-to-date living trust, up-to-date power of attorney. Those are crucial where you name, we have sometimes clients when they are starting to lose capacity, they can see it themselves. They will voluntarily, as Mike, you talked about, name a co-trustee to step in with them. So they're saying, hey, I know I'm having issues. I don't want to lose all control. I'm going to name someone to step in with me, to step in to help me and to check my decisions as co-trustee. So they're not giving up the ability to make decisions. And you might, in your power of attorney document, say, I am giving someone the power right now. They don't have to show a doctor's note that I'm incapacitated to step in and help me. So getting that in place is great. What about from a care standpoint, though? Because that goes to at least a lot of financial decision making. But what if you're facing this and you're worried about, hey, how can I be taken care of? I know there's issues of isolation. You talked about Groucho Marx. Is there a story there?
Oh, there's a story there. Groucho is one of many individuals who apparently, it's a very long, complicated story, but as I understand it, he had money, he had resources, and somebody who was close to him was taking care of him in his own home, and really isolated him from others. And what proceeded, as I understand it, as I read, was an enormous amount of financial abuse. He wasn't seeing other individuals. Nobody knew what was going on. And I've always been, frankly, kind of a critic of isolated luxury. We want to be very thoughtful about the decision about where are you going to live as you age, as we age. Many of us put the idea of staying at home on kind of a pedestal. We say, I want to be at home no matter what. Yeah, and for some that's fine, particularly if there's a community, if there's individuals who know you and you're still seeing people, or if you're a big family and they're coming around really often. But there's a lot to be said for being in a vibrant community, a continuing care retirement community where there's a lot of activities. So, how do you deal with it and what kind of stimulation do you get? Because I do believe that makes a difference in terms of your acuity, keeping it going. I want to comment on something you mentioned just now so we've got your trust where you have a successor trustee, right, to manage trust assets. You have the durable power of attorney where someone's empowered to manage like retirement accounts, assets that are not in the trust and other areas. But what you alluded to was healthcare decision making. So let's emphasize that what you need to have, and I'm sure most do, you need to have an up-to-date advanced healthcare directive. And that's where you do two things. You name somebody you trust who's empowered to make healthcare decisions for you if you can't, and very importantly, to be an advocate for you, in the healthcare system. Second thing the document lets you do is be as clear as you want about how you want those decisions made. So you can be very explicit. Mine says, by the way, under no circumstances, if I'm in the hospital and can't communicate, no rap music. Not allowed. There's a lot of music I like. I think I say that as well. But I'm very clear about not wanting rap music in my room. And again, this goes to what kinds of issues could come up. And I'm going to do a sidebar here on younger people. Here's another issue that comes up all the time. So if you guys have teenagers, if you have younger kids or somebody in college or your grandparents, picture this. The kid goes off to college, is ill. You just find out your daughter is ill. You call up the infirmary to find out what the heck is going on because your daughter hasn't called you. They can't talk to you because of HIPAA. the Health Insurance Portability and Accountability Act. It has very strict privacy restrictions. So we've had clients shocked to call us and say, hey, they won't talk to me. Help us. So the point is that when your kids turn age 18, as we did with our kids, they should sign durable powers of attorney and advanced healthcare directives that include a HIPAA waiver. It's practical.
Extra important for you, and to make sure it's up to date, because if you face these dementia issues, we're talking about what if you're starting to lose capacity and you need people to step in and help you. You need to make sure your list is up to date as well. So even if you did an advanced healthcare directive a while ago and there's some family member who now is involved and they're not named in that, you need to make sure that they are added and that you make them an active agent, because as Mike said, your loved ones, even if they are involved in all parts of your life, if they are not named in a HIPAA waiver, in an up-to-date advanced healthcare directive, they can't even talk to your doctors to get help, to get information, to look at your medical records. So I think and yes, of course, everybody over 18 needs this as well. Are there any other, celebrity or high profile or even client stories you want to tell, Mike, about people going through this and what families did to deal with this?
You reminded me, when I gave a talk on this topic at the reunion, I had many alumni from different years. I was asked to give a talk on this exact topic. Okay, so there was a member of the class of 1968. I was the class of 1973, so he's older. And he said, he asked a question. He started out by saying, he said, I've been self-diagnosed with something that I think everybody understands and really relates to. He says it's CRS. And everybody's saying, what is CRS? He said, quoting him, he says, can't remember shit. So that was a self-diagnosis he had. So anyway, again, that's not really a client story, but here is one that I think is really, really poignant. We have many situations where we've been involved with this issue. Okay, so this was a situation where a lady was taken in by one of these online telephone scams. She believed that she was winning a prize, that she had this wonderful relationship with this person who was making sure that she got her money, etc., and she was sending money as good faith to keep this thing going. And it was a clear scam, and the individual bilking her of money was very, very good at it. Okay, she told her son all about it. Son was a client of ours. Son talked to us. We brought in the police. Long story short, they set up another call with this individual to see if they could get some information or trace the call. They gave her a script, certain questions to ask. In the room with her, I am told, in the room with her was her son and a police officer on the phone with her, listening to every word. She had a script. She knew she was being ripped off. And then the call happens. And as the call proceeds, this con artist, this horrific person, starts saying all the things that work so well, cozying up to her, getting her confidence again, even though her son is there and the police officer is there. And she starts to commit to send more money right before their eyes. She was a wonderful lady who was just taken in. So that was a complicated story. And, to me, so poignant, because here was everything set up to protect her, but still susceptible and making terrible judgments. We have many situations. One was a Nobel Prize winner who wanted to marry a younger woman, and his family concluded that he was not in a position to make those decisions. Long story short, it was shown that he was able. We made a number of changes in the estate plan to keep everybody happy. But again, there's this perception and then there's the reality. And needless to say, this is not simple stuff. I'm glad folks are watching. You got to think about this.
And in that case, we had multiple meetings with him to make sure he was clear and consistent. There's no sign that he had dementia or lack of memory. So he had the right to make that call, even if his family didn't like it, right? And so that's the line here that we have to be careful of, is we don't lose the ability to make decisions just because we're older. That is ageism. Just because we have a diagnosis of cancer or Parkinson's or something like that. Dementia, okay, maybe we have to really be extra careful, but we don't want to take away the rights of individuals as they get older to make decisions, but we want to make sure people are protected if they're clearly making irrational decisions or making lots of mistakes. And that's, and we have so many times where we've seen issues like that. But we want to make sure that you can still make decisions, and empowering people you love ahead of time via your trust and your power of attorney is, I think, the best way, where you can still retain control, but name someone as a co-trustee or a co-decision maker. That's just so powerful.
Even if you have the best documents in place, think and rethink. about the person you've given to whom you've given authority. Who is your trustee? Who's named in your advance directive? Are they the right? Many individuals are great at handling money, but when they're in a hospital setting, the doctors come in with their white coats and they are cowed. Suddenly, they're just listening and doing whatever the doctor says. So, in other words, being able to manage money doesn't mean you're able to be an effective healthcare advocate in the healthcare system for somebody else. It could be a different individual.
We have other videos on the Gilfix Law YouTube channel about healthcare advocacy, the importance of having someone there with you. Whether you have capacity or not, you need someone sitting in on meetings with you, taking notes, asking questions, keeping track of things. And that's heightened, of course, when there's issues around capacity and the ability to remember things. So I want to get to we have a lot of really good questions in the chat. Let's sum this up. So let's say that we're going to get to questions in just a moment. What do we do? So from an adult child's perspective and an elder's perspective, if you start to get to that point where there are some concerns, maybe Dad, I see you paying a bill twice, like I said, or not remembering things that you've done financially, or not all of a sudden forgetting what you have and where your accounts are. What are some steps that let's take it two parts. What are some steps that adult children should take, and what are steps that the elder should take, or the person who is starting to see themselves maybe self-aware about some of the issues? What are some action items?
Good old-fashioned discussion, and I'm not naive. Sometimes it's extremely difficult for any combination of reasons for an adult child to raise this question with a parent. There could be family history that makes it awkward or difficult, and that's why sometimes you need to name a third party, a professional, to be in the role of trustee. Sometimes it isn't right to have your kid. Certainly I would make sure, if I was the kid, I want to make sure I have copies of the documents, ideally. And ideally, if you're the elder, you're going to share those documents. You don't have to share them with everybody in the family, but you do need to share them with the individuals to whom you've given authority and responsibility, the person's named in those documents. So again, it's presenting the document if necessary. That's a tool that can be used. Say, hey, Dad, I see this. I see some issues. Let's go over this. I think that's a nice, it's an entree, a segue that lets you comfortably raise some of these issues. And again, sometimes there needs to be a discussion with the doctor. Hopefully you're named in the advance directive with the waiver that we're talking about. And by the way, hey, reality is many doctors will answer family questions regardless. We know that. It's the kid context where we've seen the most difficult challenges come up. But when the wife is there and the doctor is there and the wife goes out in the hall, or the oldest kid with the doctor, they usually talk to you. We know that. I did serve on the ethics committee at the Stanford Hospital for a couple of years, and we did have a couple of these issues come up. And if somebody's being technical about it, the lines are very clear who can and can't get information. So anyhow, starting out, just raising the issue directly, comfortably, hopefully there's a lot of confidence there. And then the next generation needs to be aware of the pressure points. Where's the money? What can they watch? What do you look for? What's a logical check? By the way, there's a lot of information on the Alzheimer's Association website. What do you look for?
ALZ.org, I believe.
There's a wealth of information out there, and you would really hope also that there is communication with the physician, notwithstanding everything else I said, so that you're aware of any conditions that might be compromising. Many illnesses, by the way, we've seen so many situations where somebody seems to be losing capacity, and then it turns out that they're just incredibly dehydrated. They're not taking care of themselves. And a short hospital stay, and they're absolutely fine. So, this whole issue of capacity, there's many causes, and apparent problem with capacity does not mean that absolutely a person has lost it. There could be physiological reasons for that, and they can be addressed sometimes. Other things that I think are important, and we've done this. We've done this. Passwords. What passwords do you have for your assets? Who has access to them? After you pass away, or if you can't remember them, it's really difficult for I don't care what it says in a power of attorney, it's difficult to get that information. So making sure that your family members or your successor trustees know your password list, know where your assets are. They don't have to know the dollar amount at Vanguard, but they need to know you have Vanguard, and ideally the account numbers. So you're getting those ducks in a row. You're signing the advance directive. You're signing the durable power of attorney. Maybe you're signing the Ulysses clause, or writing a letter to your family where you express this openness, this acknowledgement that there can be issues. That's such a difficult issue. The kid doesn't want to raise it. They fear conflict. Dad's dignity is at stake, and it's complicated. So I want to raise all of those points. And let me go back for a moment. I mentioned the driver's license. In our society, driving a car is often just emblematic of independence and control. And if somebody's no longer able to drive, it's a heavy hit on so many levels. And most of you know that if your physician concludes that you have serious issues, mental or physical, that makes it difficult for you to drive, they are mandatory reporters. They have to contact the DMV. What usually happens is that you're sent a notice and your license is temporarily suspended, and then you have the opportunity to be tested. It isn't always exactly that way, but the point there is sometimes if the family members feel dad shouldn't be driving, they get the doctor and they put the doctor on notice. And if the doctor knows about issues and doesn't report it, the doctor knows there's liability there. So they have to take some of these steps. I will tell you one story, a very real story happened here in Palo Alto where a gentleman was diagnosed with Alzheimer's, rather advanced. There were many things he could do physically, but no ability to manage money whatsoever. And driving a car was so key to his existence. Again, long story short, here's what the family did. Rather than take the keys away, they put the keys to the car on a little hook right by the door going to the garage. You can push a button. You can open the garage door. Get into the car. What he would do, they told me, is he would take the keys. He would go over. He would get into the car, and he would start up the engine, open the garage door, and vroom, there he goes. The car was up on blocks. The exhaust was vented to the outdoors. Very important. And they told me, you get these stories, and I believe them, that satisfied dad. He didn't have to do it long. He'd get in the car, he'd come back in, everything is fine. So rather than fight him, they came up with a very creative accommodation. We also had another who, when dad went driving, they called the cops and they told the cops to stop their dad. That was not respectful. I didn't like that way, but hey, you do what you got to do sometimes.
I hope I never need to do that with you, Dad. You drive pretty fast sometimes, so I'll have to.
I'm a crazy. Hey, a Tesla. No, I'm careful.
No,
I am careful. So careful.
If you have these issues, if you're the adult child, and I certainly hope this doesn't come up for you and for mom, but if it ever does, I think have family meeting, and we can be a part of that. The attorney can be a part of this, by the way, to say, look, let's do a family meeting, let's come together and talk about this, but it doesn't have to involve attorneys. You have to make sure you have up-to-date trust and power of attorney, ideally ahead of time. Talk as a family. If there are some concerns and someone have self-awareness, you can empower your family to step in. Family, you got to make sure that updated documents are sent to banks and the power of attorney, that the banks know that if they empower you to help out a parent, that the bank knows this, because you might update documents, but if the bank doesn't know you've done that, maybe the adult who's exhibiting worrisome signs still has full control. So you have to update documents, let the banks know. Ideally, you talk about it ahead of time so everybody's on the same page. We got to have the estate planning documents. But if you have from the elder's standpoint, if you're self-aware of this, talk to your family, talk to us as your attorneys. Let's proactively empower people to help you so we don't have to go through these challenging steps. And I think if you are in that place where you're not self-aware and the family is concerned, couple bullet points, Dad, there. Like, again, let's just repeat that and then we'll go to some questions. So let's say, and we're getting some questions about this. Like, I am worried about my parent. They're starting to exhibit this sign, but they deny it. Just summarizing kind of what you talked about already, some bullet actions there.
If there are issues, what can be just an excellent idea is to bring in a care manager, a social worker who has experience with aging, who understands resources in the community. And to bring somebody like that in, that is not an acknowledgement of lost capacity. That's acknowledging that we need to think about where we're going to be living. We want to have a plan. So mom and dad, so you remain in control. And it's honest. This is not misleading. Saying if things come up, we want to know what's best for you, and you're bringing a care manager. And that's often another way of raising the topic. Because the care manager, who hopefully you get somebody very skilled, we have people we work with, they're not on our staff, they're totally independent, but some are very skilled at leading a discussion to raise these topics so that they can be dealt with very directly. So, because again, the question of where you're going to live directly relates to your trust and who's going to be in charge of managing assets. So again, power of attorney, advance directive, a trust, maybe a Ulysses clause, double, triple checking that you're comfortable with the individuals to whom you have given authority, making sure that your information, lists of assets, passwords, that is organized reasonably well, and that somebody in the family knows where to find it. Engineers out there are usually pretty good about this, but Here's the point. You have to assume that you're going to disappear tomorrow or lose the ability to manage things tomorrow. Ask yourself, will your loved ones be able to carry on and manage things without you? That's the question you have to ask yourself.
We don't want you to be stuck in court. We don't want you to be conned. If you have a loved one who's exhibiting these behaviors, hey, you got to hit it head on and act proactively. Don't wait until it's a disaster. Ideally, we should all cooperate and work together, because there's so much we can do to prevent these issues before they happen. And make sure your estate plan is up to date. And it's not done with some simple program or downloadable forms. You need to have a sophisticated living trust, a power of attorney advance directive. They all have to be consistent with your wishes and up to date. Make sure they're done, updated, especially as you get older, every 3 to 5 years at least. Otherwise, even if you have an up-to-date power of attorney that reflects your wishes, banks might not accept it. So make sure it's up to date. Talk to us if you'd like to explore this more. Any closing thoughts, Mike, before we head out?
I got what occurs to me is this talk, which is based on experience and having worked with so many people, underscores to me, this may sound odd, the danger of AI. There's going to be so much information available because you can now have ChatGPT write everything. But you need to talk with not just attorneys, but I mean medical, every context. We all need to be aware of this and a little bit worried, and talk to individuals who have experience. And there's no formula for these things. We're all individuals. We need to deal with them as individuals and with a great deal of respect.
For those of you who haven't subscribed to our Gilfix Law YouTube channel, please do so. Very easy. You can just point your phone at this or just Gilfix Law on YouTube. We have hundreds of thousands of views now. We're in the thousands of subscribers. We're really excited about that. This video will be there if it's not already. And for those of you who have not, so subscribe. Easy to find us. Gilfix.com, 650-493-8070. So thank you so much, and we'll see you guys again very soon. Take care.